Hi guys, welcome back to Simplify. In this video, we are going to cover an interesting topic on Indian Contract Act Part 1. Let's start with understanding some important definitions. Proposal or offer refers to a situation where one person offers to another his willingness to do or to refrain from doing something to obtain the latter's acceptance of that offer. Promise, when the person to whom the proposal is made gives his consent, the proposal is said to be accepted and becomes a promise. An agreement refers to an understanding between two parties. It includes every promise that forms the consideration for the two parties. And lastly, contract is an agreement enforceable by law. Difference between an agreement and contract is: an offer plus acceptance equals agreement, while agreement plus enforceability equals contract. All agreements are not contracts, but all contracts are agreements. An agreement may not create a legally binding relationship, while a contract always creates legally binding relationships. An agreement is not a concluded or legally binding contract. Contract is always concluded and legally binding. Essential elements of a valid contract are: proposal and acceptance, intention to create legal relationship, lawful consideration, capacity of parties, free consent, lawful object, agreement not declared void, certainty of terms, possibility of performance, and legal formalities. Contracts can be classified as validity, performance, and formation. Under validity, the subclassifications are void contract, voidable contract, unenforceable contract, and illegal contract. Under performance, there is executed contract and executory contract. Formation includes express contract, implied contract, and quasi contract. Let's understand each of these types in detail. On the basis of validity, void contract does not have any legal effect, that is, it cannot be enforced in court. For example, a contract to import foreign goods becomes void with the sudden declaration of war and restrictions on foreign trade. Voidable contract is enforceable by law. However, it can be made void at the option of either of both the parties involved, but not the others. For example, X threatens to kill Y if he does not sell his house to X for rupees 1 lakh. Y agrees to the sale of the house. Because Y's consent has been obtained by coercion, the contract is voidable at the option of Y. Unenforceable contract is valid, however, it cannot be enforced in a court of law owing to technical defects. Illegal contract is a contract that violates public policy and is forbidden by law. For example, Mr. X borrows rupees 5,000 from Mr. Y to import prohibited goods. Mr. Y is aware of the purpose of the agreement. This transaction between Mr. X and Mr. Y is collateral to the import and is illegal because the underlying agreement is illegal. On the basis of performance, executed contract refers to a contract in which both the parties have performed their respective obligations. For example, Mr. A entered into a contract with a porter for lifting 4 of his bags for rupees 80. The porter agreed and carried all the 4 bags, and Mr. A paid him rupees 80. This situation refers to an executed contract because both the porter and Mr. A have performed their respective obligations. Executory contract refers to a contract in which both parties are yet to perform their obligations. For example, A and B entered a contract where A agreed to teach B for the next academic year and B agreed to pay A tuition fees. This is referred to as an executory contract. Now, if B has paid the fees to A before A taught, the contract is executed with respect to B and executor with respect to A. On the basis of formation, express contract refers to a contract formed when the offer or acceptance of any promise is made in words either spoken or written. For example, when A enters a public bus or orders a cup of coffee at a restaurant, A enters an implied contract to pay for his ticket and the cup of coffee at the respective places. An implied contract is one which offers or acceptance of any promise is made other than in words. Quasi contracts are implied by law. Obligations between parties are not contractual but quasi-contractual in nature. For example, a trader mistakenly leaves his goods at Mr. A's house. Mr. A treats them as his own goods. Here, Mr. A is liable to pay for the goods despite the absence of a contract between them. Quasi-contracts are those relations which resemble contractual relations. A quasi-contract is not a real contract but is implied by law. Types of quasi-contracts are: Section A68, claim for necessaries supplied to person incapable of contracting. Section 69, payments by an interested person. Section 70, liability to pay for non-gratuitous acts. Section 71, finder of goods. Section 72, liability of a person to whom money is paid or thing delivered by mistake or under coercion. Let's look at each of these types in detail. Some other types of contracts are: contingent contract. It is a contract whose terms are based on the occurrence of some events collateral to the contract. Example: A enters a contract to pay B INR 50,000 if B's house burns down. This is a contingent contract. Contract of adhesion. It is a contract between two parties where the terms and conditions of the contract are made by one of the parties, and the other party is placed in a take it or leave it position with no ability to negotiate. Example: insurance policies and contracts with government agencies. Contract under seal. It is made by a deed or speciality. It is in writing and is signed, sealed and delivered by the parties. No consideration is required. Simple contract. All contracts are not made under seal are simple or parole contracts. However, they must always be supported by consideration.